perhaps better deal with one or two housekeeping matters before we begin hearing the argument. From the timetable we have, it rather looks as though, Mr. Jones, are you going to address us on both your own appeal and also your response to Mr. Flowers' appeal before we hear from Mr. Flowers?
Well, that was the plan,
yes,
because I thought it might be easier for you to hear each of us in one go.
Yep.
And the offer to Mr. Flowers was that we would, as it were, put forward our best shot on his appeal and would only then use any reply time for anything that we hadn't anticipated.
Yes.
Now, but we're entirely in your lordship's hands as to whether you will find that convenient. If you prefer to hear one appeal separately from the other, then we can rejig the timetable quite easily.
Yeah. No, we're content to hear you in one shot. Now, before we do hear you, Mr. Jones, I should say a word to Mr. Flowers. Mr. Flowers, we appreciate you're in the unfortunate position of being unrepresented in front of us. We do have, of course, the written cases that the one on the principal appeal that was prepared by Mr. Poole, King's Counsel, and also your own one on the cross appeal. And clearly we've been greatly assisted by seeing those in advance. The way we're going to be proceeding is we'll hear oral submissions from Mr. Jones on both his own appeal and his response to your appeal. Then you will have an opportunity to make any oral submissions that you wish to. And then Mr. Jones will have a brief right of reply. Is that all?
It is, my lord.
That all clear?
I'm very comfortable with that. Thank you. Yes.
Fine.
Thank
fine.
you.
Very well. Yes, Mr. Flower.
Lord, thank you.
And Mr. Jones.
So, as your lordships already know, there are two separate appeals. I'm going to call them the credits appeal and the icebreaker appeal for shorthand. And the short summary by way of background is as follows. And I'm going to take this quite shortly, but let me just reiterate some of which is in the short statements, but I will add one or 2 points. EIC is a Gibraltar registered insurance company. It was set up in November 2003 to benefit broadly from 3 things. One was the tax regime offered by Gibraltar. The second was the regulatory regime offered by Gibraltar. And the third was the ability to use passporting rights to sell insurance throughout the European Union, of which the UK was then a member. Now, Gibraltar provided the home for a number of successful insurance companies, and may I just say that nothing we're going to submit here, or that we've submitted elsewhere, should be taken as a criticism of the validity and propriety of the regime that Gibraltar offered, or the ways in which other successful companies had operated apparently lawfully within that regime. But this is not an attack on how insurance was run in Gibraltar. By contrast to those success stories, however, EIC was regrettably something of a disaster, as it is one of Gibraltar's largest single insurance failures to date, if not the largest. And the reference for that, and I needn't ask you to turn it up, is Mr. Justice Rastane's judgment, paragraph 21 in the bundle at page 132. EIC was placed into provisional liquidation in July 2016 and into liquidation in October 2016. EIC, in liquidation, brought claims against its former directors, a sister company, EIG, I will call it throughout, I hope correctly, its holding company, EHL, and a shareholder of the holding company called Roan Holdings, or RHL. I'll come on to explain more about that ultimate shareholding in due course. Now, those claims gave rise to a 41-day trial in 2022. Settlements were reached either before or in the opening days of the trial, with every defendant except Mr. Flowers, who went on to judgment and lost. Judgment was given against him in 2023. Mr. Flowers attempted to appeal every aspect of that judgment in the Court of Appeal, but he failed in that endeavour. And while some points went in his favour, the core of the case brought against him was upheld. Now, the core of the case against Mr. Flowers was twofold. One, that he was liable for presiding, regrettably dishonestly, over a 12-year regime in which EIC had paid away a little over £50 million, ostensibly for services, where the true position was that no services were provided by the service provider, EIG, or received by EIC. Now, that case succeeded at trial, and his attempts to overturn it on appeal were unsuccessful. The second of the twofold core was that he caused EIC negligently to underwrite policies to indemnify the losses of investors in a tax avoidance scheme called Icebreaker, leading to claims on those policies. That case succeeded at trial, and his attempts to overturn it on appeal were unsuccessful. So the difference between those two is that we had alleged, but we did not succeed in the allegation of anything other. We only succeeded in a negligence claim in the second core case, and nothing beyond that. You may have read that Mr. Justice Restano acquitted Mr. Flowers of having dishonest intent. So can I now move to EIC's appeal and start with that, the credits appeal? EIC's appeal to your lordships concerns one aspect only of the first of those core cases and relates specifically to the way in which the quantum of EIC's case is to be calculated if the Gibraltar Supreme Court later comes back to that aspect of the case to make the assessment of recoverable loss. One might hope at some stage that we wouldn't need to do that, but if we need to go back to the Gibraltar Court, then it needs to be told whether it was correct or not correct in the first instance, in the way in which it was setting out to address the question of quantum. Now, EIC was successful at trial on this one remaining point, but EIC's success was overturned by the Gibraltar Court of Appeal, and on this appeal, EIC asks this court to reverse the finding of the Gibraltar Court of Appeal and restore the finding of the trial judge. When making these oral submissions, I'm not going to read out or repeat what's in the statement of case. I'm going to make, I hope, the correct assumption that your lordships have read it or will read it in due course and have it in mind.
No, we have read it and we've been thinking about it.
I assumed as much, and therefore I'm going to take things, if I may, in a slightly different order, as I hope will assist you today. So I now want to come to a heading which I would call the background in more detail, having given you a very short summary of EIC and its brief and sad history. In this background in more detail, I wish to make 9 points to set the scene, and those points will provide the factual background, the unequivocal and unchallenged findings of the trial judge and the Court of Appeal, and the conclusions to be drawn from them, which are relevant to the arguments on the credit question. To assist any notes your lordship wish to take or any later reading of a transcript, I'm going to number those points, I hope not laboriously, but I will try and give the chapter headings and sub-chapter headings as I go through it. Point 1 concerns EIC's status and the principle of capitalisation. Now, EIC is an insurer. The characteristics of an insurance company will be well known to your lordships, so I'm going to take this swiftly, but the points I'm making are specifically relevant to the arguments. The first sub-point I wish to make is this. Insurers are required by regulations to be adequately capitalised. The starting capital required when EIC was incorporated and licensed was £2.5 million. The level of capitalisation required is set by the regulator, in this case, the Gibraltar Financial Services Commission, or GFSC. Little b, the level of capitalisation requires a regulatory minimum margin, which is always used by definition RMM. Now, the basic RMM is, put simply, a margin of assets over liabilities to meet claims and general overheads of the business. In addition to the basic RMM, the regulator can impose an additional margin above the basic one. And the evidence was that EIC repeatedly failed to meet its RMM requirements, and it was unable to meet the requirements for each of the reporting periods. Just to give you a flavour of that, which
basic and additional. Basic and additional margins.
Yes. So I'm not suggesting we go to it now because it covers 6 paragraphs, but if your lordship wanted to see the origin of what I'm about to say, it's in the trial judgment, paragraphs 161 to 167, bundle pages 191 to 193. But in short order, in October 2009, the GFSC required EIC to maintain a solvency margin of at least 120%. So the 20% is the uplift on the basic. This followed EIC having been put on a 24-month supervisory cycle in April 2009, and prior to having been granted a licence to underwrite motor business, which happened in November 2009. In September 2010, the GFSC prescribed a premium limit of 25 million to the year end to July 2010, given concerns raised that EIC did not have the appropriate capital in place to write its forecasted business. The capital only being sufficient at that point to write 25 million. Despite the premium limit, EIC proceeded to write over £50 million worth of business. The limit was again succeeded in the financial year to March 2012, when it wrote over £75 million worth of business. Subsequently, the GFSC required the margin to be 150% of the RMM, although this was then reduced briefly to 125%, with an expectation that 150 would then be achieved. So that detail is in there. I've just given that to show the extent to which these failures were clear. My subheading C is this. When an insurer writes business, it receives a premium. I know that sounds impossibly simple, but let me develop it if I may. That premium will typically be dispersed in part to fund the costs of acquiring the business and administering the business. But the company also has to retain or require sufficient capital to meet future claims, which can occur many years later. The problem with an insurance company, as your lordships will know, is that capitalisation is essential because of the inflow of premium. It can also always appear cash-rich on a cash flow basis. So that first heading of point 1 deals with what I'm calling the principle of capitalisation. Point 2, if I may, is to move on to what constitutes capital for the purpose of that principle. Now, this point deals with the rules relevant to this case concerning the question of what constitutes or does not constitute capital for the purposes of operating that principle of capitalisation. For our purposes, there's one rule here and one only. We needn't go into the regulations in any detail because this is not an issue. An insurer was not able to increase its regulatory capital by borrowing money. An insurer may, of course, in other respects have been able to borrow money and thus increase practical working capital in the sense that it would have the borrowed money in the bank to pay for its overheads. But for the purposes of the relevant regulations and as operated by the GFSC, borrowed money was treated as being offset by the equal and opposite obligation to repay it, and therefore it did not count as having increased the capital of the insurer for the purposes of the RMM. Now, the defendants adopted a description of this regulatory rule, which Mr. Flowers and others called, with capitals, the insurer-borrower constraint. And were you to want a source for that for Mr. Flowers, it's his defence, paragraph 15 in the bundle at page 979. I don't quibble at the definition. It was very useful to have it, and it's useful now. Now, the entire reason for the defendants deploying the argument called the insurer-borrower constraint was to show the DIC could not increase its capital by borrowing money. As we will see when we come to my point 4, this provided the background for what has become known in this case as the triangular model. It was called, I think, in his original pleadings, the triangular arrangement by Mr. Flowers, but triangular model was the one that then got universally adopted. Now I move on to my point 3.
Well, what does constitute capital for the purpose of the capital requirement?
For today's purpose, it would be unencumbered capital, but there are complex rules about that, but the only one we're concerned with.
Is share capital?
Yes, but one would need...
So when somebody pays for shares, subscribes for shares, they pay over money, and
yes,
that money counts as capital for this
yes,
purpose.
So when I said earlier that you could start an insurance company back in 2003, 2004 with 2.5 million, that would have constituted the initial capital. Whether 100% of it was to be treated as capital for the purposes of the RMM would then depend on what other obligations the company took on. So what I'm not doing is giving you a complete picture of everything that would constitute reckonable capital, because that's a complicated affair. What I am doing...
I'm just asking you a simple question,
yes,
which is that if the company issues shares and somebody subscribes to those shares by buying them and giving the company money, that counts as capital for this purpose?
It would count as capital unless it were offset by some other obligation that the company took on within the regulations which diminished it.
Such as, well, they wouldn't, I mean, they have obligations to the contributory who's subscribed to the shares, the obligations of that a company owes to the shareholder, but that wouldn't prevent it from being capital for this purpose.
No, but the RMM, the basic RMM, is simply assets over liabilities. So all I'm saying is I'm not saying that one starts with 2.5 million forever a day, because one might take on liabilities which would diminish it.
Yes.
It's basically a balance sheet test, is it? A balance sheet test.
Well,
we're looking at more, roughly speaking.
It's assets over liabilities if a balance sheet test, but with the regulation telling you what goes into the balance sheet and what can't go into the balance sheet for this purpose. So I'm reluctant to use the balance sheet test because you could have a balance sheet.
Not ordinary accounting rules, it's special rules. Okay.
And because the balance sheet test might, in certain circumstances, allow you to include in your capital money that you borrowed. And for our purposes, this regulation did not. So that's the reason I focused on that, and it's critical to understanding what happened in this particular case. So forgive me, lady, if I didn't understand the question you were putting to me as swiftly as you would have liked. Can I now move on to point 3, which is no ability to declare a dividend? This is a single issue point which I can express in 3 very short paragraphs. The GFSC was able to dictate whether and in what circumstances an insurer may or may not be able to declare a dividend to its shareholder or shareholders. B, in this case, the GFSC licensed EIC, consistent with other licensed insurers, on the basis that it could not declare a dividend without the GFSC's consent. EIC never reached the position where the GFSC would have permitted a dividend. EIC never sought such consent, and none was given. Accordingly, EIC could not lawfully pay a dividend. Now I'm going to come back to point 4, which I introduced earlier as headed the triangular model. Now, this point concerns a corporate structure accepted in principle by the GFSC as a means of operating within the rules, but in a way that facilitated borrowing that would count towards capital adequacy and therefore resolve the question of the insurer-borrower constraint. And that structure was given the name triangular model, and I'm now going to take you through 6 short paragraphs by way of explanation. A, the triangular model is not an insurance or financial services term of art, and you will find a reference to that in the Court of Appeal's judgment at paragraph 90. But we've been prepared to adopt it at all stages for ease and to assist with understanding the arguments. B, the corporate structure and idea behind the triangular model are both simple enough. The model proceeds on the basis that the insurer is set up as being owned by a holding company. The holding company also incorporates an unregulated sister company. The purpose of the sister company is to provide services to the insurer for payment. Those services would be provided at a commercial rate which the directors of the insurer operating lawfully would have to be satisfied was reasonable for the insurer to pay. And that... I can't get in. Let's pause for a moment.
I think you might perhaps have to pause for a moment. You have a technical problem.
I'm very sorry. As long as we don't need to refer to any documents, then I don't need to hold it up.
Right. Very well then, Mr. Jones.
Right. I will come back to documents, but I'll make sure that this is resolved before I get into them. Thank you. So that explanation is clear, and I haven't made a note of it, but I will, before I leave today, give you some paragraphs from the trial judgment, which sets out that basic requirement. C, the service company could then make a legitimate profit from the provision of services, out of which, being unregulated, it could declare a dividend to be paid up to the holding company. By contrast, even if an insurer chose to provide the services in-house and, as it were, retain the profit, which it could do if it wished to, it would not be able to declare a dividend on that discrete profit element because of the prohibition on declaring a dividend, which would have to be on the overall profit of the company. Point D, the holding company could, if it chose to do so, but it was not obliged to do so. A key point, it could borrow money because the holding company itself had no regulatory borrowing constraint, and it could then use the borrowed money to inject into the insurer and thus increase the capital of the insurance company and thus overcome the insurer-borrower constraint. I can give you, in fact, paragraph 13, just for your note, of the Court of Appeal judgment, page 504, describing the triangular model. I'm very grateful. That's probably better than going back to the trial judgment.
That's a separate point from the triangular model in a way, isn't it? I mean, the point you've just made, they could borrow money and buy shares anyway, whether it's part of the triangular model or not. And the triangular model could work without them doing that.
Well, the purpose of it, as I understand everything that we were told when we were in Gibraltar, certainly from the defendant side, the purpose of the Gibraltar model, the triangular model, was to overcome the borrower constraint so that if money needed to be borrowed to inject into the insurer, it could be borrowed at the holding company level using the profits legitimately dividended up to it.
I see. Otherwise, it couldn't borrow money, the holding company.
Well, the company could always borrow money itself, yes, if it wished to. I'm so sorry, I'm misunderstood the point. Yes, of course it could do that in the ordinary course of events, because being unregulated, it could do whatever it wished. So that's, yes, that's...
But if the holding company borrowed money or had the money spare itself and wanted to inject it as capital into the insurer, it couldn't do that by lending the money to the insurer.
No.
Because that would create an intra-group debt which would cancel out that injection. Is that
yes, it would have to
why
subscribe.
in this case it subscribed for shares?
Shares, yes, yes.
And if the holding company didn't have any profit-generating activities of its own, then it would depend upon dividends from EIG in order to service any loan.
Yes. So one may say that there are two ways to run a tripartite group of this kind. One with a holding company with its own source of income, and one with a holding company which had a source of income coming up through the sister company. Yeah. But for this purpose, for the purposes of the triangular model as it applies to our case, then it's the latter. That doesn't stop the holding company from acquiring different capital, perhaps from its ultimate shareholders, in the conventional fashion. But the idea was that the sister company profit would be dividended up. Now, if I move on to my fifth point, it's plain and obvious, we say, that the purpose of a properly operated triangular model was to use payments coming out of the insurer to the sister company for a legitimate and needed service, which then generated a legitimate profit, which in turn could be used by the holding company to increase the capital going into the insurer in a way that would count for capital solvency requirements.
And does the regulator look at these triangular models to see whether there's some services being provided by the sister company?
I'll come on and deal with that in the licensing aspect of it. The answer is yes, it did. It looked at the time of licensing at precisely what services would be provided by EIG and at what cost. And it reduced the services and the costs before the license was granted. And the evidence was it at all stages assumed the services were being provided and never knew that they were not. So the answer is it was licensed.
The answer is that's to a slightly different question. They might do it at the outset, but they don't kind of check as they're going along, as everyone's going along, whether anything is actually being provided.
No, because that's a matter for that would then be a matter for the directors. And my understanding of directors' obligations would unquestionably require them to check every year that they were getting value for money and to market test what they were getting. They couldn't simply rely on the fact that they were originally licensed to do something if that turned out to be wholly unnecessary or unhelpful. So if the... I'm reminded that there did come a time when the GFSC did ask some questions about services, but for my purposes, I don't think anything turns on that. If your lordship thinks at any stage something does turn on it, then we'll investigate it a bit more, but I don't think it affects the credits, the principles of going to the credits question. So my final point in this point 4 is this: if the triangular model was a way of lawfully circumventing the insurer-borrower constraint, then a model in which the holding company only paid back less than the insurer had paid out could not be said to be overcoming the insurer-borrower constraint, because it would never increase the capital of the insurer. And I will come back to that point a little later, because what we have in this case is a sure and certain knowledge that, based on the decisions of the trial judge and the Court of Appeal, less came back than went out. The question is, how we treat some of the items that came back. So, to come back to your
Could you
legislative
repeat that last proposition again? A model where the holding company only paid back less than the insurance company paid out could... What was the proposition?
The proposition is this, that if the purpose of the triangular model is to overcome the insurer-borrower constraint, that must be because one wants at a holding company level to increase the capital of the insurer. If 8% of gross written premium is paid out every year, and then in due course the holding company subscribes for further shares, but only ever subscribes for further shares with sums of money less than what has been paid out, then that regime is not being used to increase the capital of the insurer. Because
Well, it is in part, but the parent wants a dividend for other purposes as well. That's not unusual. I mean, it's got to pay its own shareholders.
What you're doing is you're looking at the before and after.
Yes.
And saying before the illegal payments, the capital in terms of the RMN requirement was X. It's not reinstated to X as a result of the,
yes.
So
the system
payment of
was...
services and dividends.
I thought you were talking about when it's legitimately done. So are you saying that if the triangular model is being used legitimately, then all the dividend that's paid up by the service company to the parent will then be used by the parent to inject capital into the insurer?
No, lady, I think if I say so, you might be conflating 2 points. To overcome the insurer-borrower constraint, which is the defence case, Mr. Flowers' case, was the justification for the triangular model. To overcome the borrower constraint, you would expect the holding company to use the income dividend going up to it in order to borrow money. That may be perfectly legitimate. Then the money that's borrowed can be injected into the company. There would be no purpose in the triangular model if all that happened was that £50 million was paid out under the sister company contract, and I'm going to come on to that in a minute, and let's say for the sake of argument only 40 million was paid back. There would be absolutely no purpose in doing that, none whatsoever, because if the money had stayed in the company, it would have had £50 million of the capital and not 40. So, and that's absolutely critical to understanding how this model was abused, as both courts below this court have found, and is not the subject of an appeal. So we assume, we proceed on the basis that this triangular model was abused.
So are you saying that when the triangular model is being used in the customary way, the dividend stream coming from the service company to the holding company is used to support borrowings by the holding company, which are then injected as capital into the...
That would be typical, because the unregulated holding company doesn't have the borrowing constraint. So it can have borrowing on its books without then diminishing the capital of the insurer, because the borrowing is not on the books of the insurer. That's the, if you like, the cleverness of the triangular model. Yeah. I mean, one accepts that it was...
And the capital injected can then be much more than the dividend income, because the
yes.
dividend income is only required to service the loan.
Yes, absolutely so. So that was my sixth point under the heading, the point 4, dealing with the triangular model. So now can I come on to the licensing regime, which I hope will answer Milady's questions. Now, the GFSC licensed
What point are you up to now?
I'm now point 5, forgive me, and the heading is EIC's licensing regime. So the GFSC licensed EIC on the basis of a triangular model. It knew there was going to be a triangular model. At the licensing application stage, I've got 3 points here. This is the first one, little a. At the licensing application stage, the GFSC received a request from EIC that it be permitted to enter into a service contract with the sister company, under which it would pay away 17.5% for a range of proposed services. And we find that in the trial judgment, paragraph 584, bundle page 353. Point 2, the GFSC wanted more information about that and was concerned about whether EIG, the sister company, would itself be undertaking licensable activities.
I'm sorry, that last reference, did you say, Mr. Judge, was it page 584 of the bundle?
No, do forgive me. If I said page, I was
Page
in error.
353, did you say?
It's paragraph 584 of Mr. Justice Rustano's judgment,
Fine.
bundle page 353.
Thank you very much.
My apologies.
No, my fault.
Now, the GFSC, as I say, wanted more information about what services were to be provided to justify 17.5% of gross written premium being paid, and they also wanted to know whether those services would themselves require regulation. Now, and a licence. I don't wish to be misunderstood here. No one was suggesting, not even the GFSC, that the sister company would need a licence as an insurer. But if, for example, what it was going to undertake for its 17.5% was insurance management services, it would require an insurance management licence. Third point under this point 5 is this. Following a series of negotiations, which the detail of which are not necessary for today's purposes, and following amended licence applications from the promoters, EIC's licence, when granted, permitted it to contract with EIG, the unlicensed sister company, who would provide only marketing services. Those were set out in a marketing services agreement. The precise nature of the services were defined. That's called, references the MSA. Those services did not require any separate license for the sister company. And they were to pay away, for that, they could pay 8% of gross written premium. Now, you will see a reference, if you read back through the judgment, to being initially 7.5. I don't think we ever resolved at trial why it went up to 8, but it did, and nothing turns on that. I only mention that in case you subsequently read it and wonder if I was accurate. While that percentage appears low, it was calculated by reference to gross written premium, and the percentage of the net premium after paying for acquisition costs to brokers and the like was between 11.5% for motor and 40% on other types of business, of net. So the fact that it feels like quite a low number, in fact, out of net revenue...
I'm not sure it feels particularly low for marketing services, if that's all it is.
Well, I take that point, but the answer is out of net premium, it was significantly more. Can I now move on to point 6? And this is the heading for this, please, is key trial findings of fact, which are relevant to points 1 to 5. So these tie in to what we've already introduced you to. Now, obviously, the trial judge had an extensive investigation, and he made the following key findings, and let me walk you through them. I think I can do this in 6 subheadings. So the first subheading A is this: no services were provided. That's the heading. It's also the substance to it. He found that EIG provided no services at all for the 8% paid of GWP to it, in addition to which EIC paid excessive sums for the use of a software system called Pi. Both of those being subject of dishonest conduct on Mr. Flowers' part.
Are you going to give us the paragraph numbers of those findings?
I will give you all, at this point I haven't got it, but I will do. Point B, Mr. Flowers knew that no services were being provided and that Pi payments were not justified. C, this was not the triangular model. The operation of the scheme by Mr. Flowers was not the operation of the triangular model at all, but a dishonest enterprise, so that Mr. Flowers could decant money, that's an expression used by the trial judge, out of EIC and spend it free of regulatory constraint, as the trial judge put it, outside regulatory purview. Because once it had gone to EIG, there was no regulatory constraint over how it was used. My fourth point is subheaded this: break-even and premium ahead of capital. The GFSC wanted EIC to comply with its regulatory obligations and to ensure adequate capital was in place before business was written. It might strike you as being a fairly obvious requirement for the regulator, and one which the company might well have been inclined to agree with. However, in contrast to that, Mr. Flowers ran EIC at as close to break-even as possible and used the triangular model to control EIC's access and not to enhance it. And that, we will come to the origin for that, but that's recorded by the Court of Appeal.
So you could give me that point again, isn't it?
Yes. Mr. Flowers ran EIC at as close to break-even as possible and used the triangular model to control EIC's access to capital, not to enhance it.
Yes, when you talk about using the triangular model, you're really meaning the form of the triangular model was adopted, but the substance was very different from the way that model would legitimately operate.
Yes, it was ostensibly the triangular model. That's how it was licensed, but it's not what was operated. My second sub-point under break-even and premium ahead of capital is this. Mr. Flowers operated a deliberate system under which the company wrote premium ahead of capital and did so in breach of any proper application of the capital solvency rules. 3, he played a game of what I'm going to call cat and mouse to obscure that operation from the GFSC. 4, he then arranged to provide EIC with the minimum capital needed to keep the GFSC at bay. And that is a direct quote from the Court of Appeal.
Sorry, could I have that point again? I'm
yes,
very sorry.
He then arranged to provide EIC with the minimum capital needed to keep the GFSC at bay.
Thank you.
And at bay is not by use of language, it's the Court of Appeals. So my fifth heading under this point 6 is called staff costs. Now, this is a good example of why this was obviously an abuse. To start with, all staff were employed by EIC, even though 8% of GWP was being paid to EIG, ostensibly so that EIG could provide a service. Now, the court has concluded that it never provided that service, so that question's not an issue, but actually it never had anyone employed at that point to provide a service. It still received 8% for gross written premium. There came a time when some staff were transferred to the books of EIG. The court at trial investigated that closely and held that it was not done because EIG had started to provide the services. It was done for an entirely collateral reason, and EIC continued to pay all the staff costs for those staff transferred to EIG, in addition to the 8%. And still no services were provided. Now, that remained the position for the first 9 years of its existence, during which EIC paid the cost of all of EIC's staff and all of EIG's staff, and no services were provided under the MSA. After that time, EIG started to pay the costs of those ostensibly employed by it, But as the trial judge clearly found and the Court of Appeal upheld, and it's not appealed, even when EIG met the staff costs, all staff were effectively employed by EIC and still none of the services were provided. But it just goes to show how odd and how abusive the system was, that EIC was, for 9 years, paying the staff costs in addition to the staff costs.
When did this switch over occur? How?
The switch occurred in 2013, but I should clarify that there was a backdating, I think, for costs during the previous 2 years, but that decision wasn't taken until 2013. You will see in the judgments that there is a credit we have given in relation to that, which I'll come on to explain in due course. In other words, we don't seek our damages to include the money that EIG eventually paid towards its staff, even though it was still providing no service. So my sixth sub-point under this is called improper disguised dividends. Mr. Flowers was originally a 15% shareholder in the holding company, and his interest through a family trust was increased.
Did you say 50%?
15.
15.
Sorry,
In EHL?
EHL, yes. And that was increased to 50% in around April 2007, following a management buyout. In February 2010, his family trust exercised an option to buy the remaining 50%, which was sold.
So he was a 15% shareholder in EHL through a family trust, and
Yes.
then that grew to 50% following the management buyout.
Yes. Then he exercised an option in 2010 to buy the other 50%, which he then sold to Roan Holdings. You'll remember I mentioned them as one of the defendants. Roan from 2010 until 2015 was the other 50% shareholder at UBO in EHL.
Was that an independent business?
Yes.
Well, that was his colleague, wasn't it, whose name I forget, who also got, yes, so he bought out the other shareholders and then gave 50% to Roan.
Roan Holdings. And Roan Holding, for this purpose, was an independent business, entirely so. That remained the position until 2015, when a Mr. Evans came along and bought out Roan. Mr. Evans was another one of the defendants who settled. Now, I'm now going to talk about Mr. Flowers and his fellow shareholder.
But this triangular model, everything you've been describing, that was a constant, apart from this shifting of the staff in 2013, that was a constant throughout the period from its incorporation
Yes, the corporate,
to the liquidation.
the corporate structure didn't change. Yes. Now, I'm now going to talk about Mr. Flowers and his fellow shareholder being 50-50, and when I talk about that, I'm talking about Mr. Flowers and his family trust and Roan Holdings. Now, each of them, that is to say, Mr. Flowers and Roan Holdings, each of them received in excess of £6 million, over £12.25 million, I think, in all, directly from EIG. Not as shareholders in EHL, but directly from EIG. I'll come back to that characterization of that in a moment. Mr. Flowers himself received further money or benefits from EHL, as did Mr. Evans and another man, Mr. Longstaff, who was also a defendant who settled. I'll come back to the precise numbers a little later. Now, I'm going to stick with the just over 6 million that went to Mr. Flowers and to Roan Holdings out of EIG, not from EHL. The books of EIG stated that Mr. Flowers had provided EIG with directors' services. to the value of just over 6 million. And that Roan had provided consultancy services to an almost equal value. However, the trial judge found, and the Court of Appeal upheld, and it is not appealed, that no such director or consultancy services had been provided, and the payments were a disguised dividend to get around the regulatory restraint on the EIC paying a dividend. That is the holding of the trial judge, accepted by the Court of Appeal. As Mr. Flowers' finance director described it in an email to which Mr. Flowers was in copy, it was much easier for the shareholders to take profit from the unregulated company than the regulated one. And you'll find that in the appeal court judgment at paragraph 69 in the bundle at page 526. So now you know why
wasn't Mr. Flowers also a director of EIC?
He was a director of EIC, EIG, and
yes, but did he get director's remuneration from EIC?
He wouldn't have got 6 million. But,
well, that's.
that.
Well, is the level of director's remuneration from a regulated insurance company something that is controlled or supervised by the Commission?
My recollection is, and this is only from recollection, lady, that he was paid director's fees in EIC of about £500,000 on the books of EIC, which then would have been inspected by the regulation, of course.
And was he was also director of EIG? He
was, but which provided no services. So the difficulty Mr. Flowers had at the trial is that the moment he charged EIC £6 million for providing director services to EIG, all EIG did was audit the 8% that came in and send it up to EHL. And the judge, for perfectly understandable reasons, I respectfully say so, held that those were disguised dividends, were not proper payments. No director's services were provided, and no consultancy services were provided to justify those sums, any of them.
But how could they be a disguised dividend? He wasn't a shareholder of... I thought EIG was wholly owned by...
It was a... Forgive me, my lady, I interrupted you, I'm so sorry. It was a way of getting £6 million out of the 8% into Mr. Flowers' pocket by pretending that he was providing services to EIG, which he did not provide.
I don't understand why he describe it as a
disguised dividend from EIC.
Yes. It's its way of getting money out of EIC via the improper use of the MSA for services which weren't provided, which went straight to EIG and straight into Mr. Flowers' pocket and into the pocket of the 50% shareholder.
I think all it means is that he couldn't pay a dividend, and therefore this was used as an alternative way of achieving what would otherwise have been done by dividend if had that been permitted.
Lord, absolutely so. And there was an email which you'll see referred to in the judgment of the Court of Appeal, which made very clear that Mr. Newing, the finance director, viewed as indistinguishable the 8% and the money that went out because it was the value, as he called it, the value to the shareholders. So the directors' emoluments and the false consultancy fees were, in his mind, value to the ultimate shareholders.
I think what may be troubling my lady is that I'm calling it a dividend, although neither Mr. Flowers nor Roan were shareholders in either EIC or EIG. But as I understand it, it's really a sort of shorthand.
Right.
They were shareholders in the parent company.
Yes.
And if a dividend had been declared by either EIC or EIG, that dividend would have been payable to the parent company of which they were the shareholders.
Yes.
So it was really a way of achieving the same practical result as a dividend, in that the money ended up going to the shareholders and the parent company.
Which was, for whatever reason, was done by dishonest means to make sure that, possibly, I can't speculate, but which ensured that the money never reached EHL. That's a significant point in the argument that we have in this case. So that money never reached EHL So EHL couldn't make an independent decision to use it for the purposes of getting around the insurer-borrower constraint by popping money back into EIC or borrowing money to put into EIC, because that money disappeared. And in fact, the amount of money that was that went out of EIG, which never reached EHL, was 12.25 million. In round terms.
But these disguised dividends that we're talking about are distinct, as I understand it, from the 8 million capital subscription for shares and the 24 million raised on the German bond markets and then used to buy shares, which this appeal is about.
Yes, correct. But the point is that I'm going to come on to develop. I'm going to have to speed up if I may. I don't wish to avoid questions being bowled at me, but I'm going to run out of time if I'm not careful. The point I'm going to come back to in due course, which ties these points together, is that the only reason that EHL had to borrow £24 million, which it did, was because it didn't have the £24 million that it got, either because in the 12.25 it never reached it in the first place, or it reached EHL and it was spent on other things. Mr. Flowers, for example, also received benefits from EHL.
Yeah. If it helps you, Mr. Jones, can I say, if you find yourself if you feel you're going to run short of time, I wouldn't spend so long on the facts, because I think we understand the facts fairly well. What we're really finding difficult in this case, or challenging at any rate, is the law on your principal ground of appeal and what test we apply. And is it the same test if we're looking at the law of equitable compensation as it is if we're looking at the law of damages?
We're content, I think, which we've confirmed at all stages, that we don't seek to draw a material distinction between those two for the purposes of this case. Yeah. Whether we could have done is lost in the histories of time, but we never have.
So this 12.4 million, whatever, that's nothing to do with this case.
Let's
get to the money that was injected into EIC by EHL by subscribing for the share.
With respect, can I say it's very much to do with this case, because what we know from the facts is that EHL made a decision to borrow money on the Frankfurt Stock Exchange. Let me deal with that now. Which it only had to do because it no longer had that number of £24 million, which had been paid improperly from EIC to EIG and dividended up to it. In part dividended and in part given to Mr. Flowers. So the decision to borrow money was not the triangular model to increase the capital of EIC. It was to replace money which had been improperly removed, not only by provision of no services, but also by paying £12.25 million to the ultimate shareholders under the guise of services that they themselves had not provided to EIG, quite dishonestly. So that's what required EHL to borrow money. It had nothing whatever to do with the triangular model. It had nothing whatever to do with utilising money from EIG, which had been dividended up, which could then be used to borrow money to increase the capital of EIC. What it had to do was to borrow money which should never have been taken from EIC and should always, on that view, have been available to be put back, but wasn't. So the key question here, we respectfully submit, in relation to the borrowed money, the 24 billion has an additional point to it. We also maintain our arguments in relation to the 8.3 as well, as you know. Those were the arguments which were sustained before the trial charge. So we're not abandoning those, but I would invite the court to focus on the 24 million, because the 24 million was undoubtedly not putting back the money that had been improperly removed. It was a decision by EHL taken when under pressure from the GFSC to find additional capital to borrow money in order to inject it And when it,
I've a bit difficulty seeing why this particular feature is relevant. I mean, if I take money out of a trust fund, I'm a trustee. I spend it. I don't have the money to put back, but I take out a personal loan, which I'm liable for, and I use that to repay the money I took away. Then I've restored the trust fund, haven't I, to that extent?
well, Lord, in this case, no, because as the Court of Appeal held, the trial judge held, the only method by which EIC could stay afloat would be if it continued thereafter to pay 8% of gross written premium in order that the 24 million which had been borrowed could be repaid in effect in the real world by it. So let me just take a stand-back analysis for the moment. I just invite your Lordship to assume that the Frankfurt Stock Exchange was a 5-year bond at 5%. Perhaps I mean a 6-year bond at 5%, it doesn't matter. But I want to get from 24 to 30, just for the sake of simple arithmetic. So there's 24 million comes out of EIC. No services are provided, and it's spirited away. It goes to Mr. Flowers, it goes to Roan, and at least 22 million, as you'll see from the evidence, went in that route. EHL then has to borrow money in order to keep the GFSE at bay, to keep EIC going. It puts in 24 million, just concentrating on the 24 for the moment. As the Court of Appeal said, in the real world, it then had to repay that money. So we start with EIC owning an unencumbered 24 million, which was premium. It was encumbered, albeit, I entirely accept, with the obligation to meet claims. I'm going to come back to that in a moment. But in all other respects, it was its own money. Out went the 24. It disappears, some of it from EIG, some of it from EHL. EHL, under pressure, then has to go and borrow that money, which it should never have had to have done. And in the real world, EIC then has to continue working and continue to pay 8% for nothing in order to repay that money. So if one stands back and says it had 24 million to start with, it then's given another 24 million, which it then has to repay plus 6 of interest, taking it to 30 million. At the end of that process, it would be 54 million out of pocket. And the person who took the first 24 million says, I'm just saying to you, that he should get a full credit for the 24 that was borrowed and paid in. That, on the face of it, has not restored EIC at all to the position it was originally in. It originally owned 24 unencumbered million pounds, and it then owns 24 million pounds, which is encumbered with the obligation to repay itself both the capital and the servicing interest on that.
It isn't legally encumbered.
No.
It's not legally encumbered, no. In the real world, it is, though. So when
How did you get to 54 million?
I get to 54 million, my lord, by saying the first 24 was taken away, 24 is borrowed and paid back, and the 24 that is injected second time round has an interest obligation on it of 6 million. So therefore, EIC has to then find 30 to keep the EIC game afloat. And 30 plus 24 gets me to the 54. So it starts with 24 unencumbered million pounds, and it would end up under this scheme 54 million short, having received no services.
But all this involves looking at economic effects and ignoring legal obligations and rights.
Well, my lord, there are two things about that. May I say this? It absolutely without question that EHL was not obliged to do anything to capitalise EIC. We've always acknowledged that, and that was made clear by Mr. Flowers. He said, EHL, he asserted at the trial, and the judge accepted, that EHL could do whatever it wanted with the money that reached it legally. And it did. It actually used some of it to buy a gastro club in Oxfordshire. Nothing to do with EIC, capitalising EIC at all. You'll find that in the judgment. So EHL was, for this purpose, an independent company. There's no finding of wrongdoing against EHL. We've settled with EHL, but there's no admission of liability. And EHL made its own decision, independent decision, to borrow money to put capital into EIC. I have got a short section at some stage to get onto questions of intention, were that to dovetail with the Gatwick case, which I know that two members of this court signed off only last Wednesday and handed down. But if one was looking at its attention, EHL did not, when it paid the money into EIC, intend to relieve Mr. Flowers of his wrongdoing. What it intended to do, independently, was to keep the GFSC at bay by putting in as much as was needed to keep EIC going. And that...
Well, what it intended to do with the money was increase the capital of EIC.
Well, lady, only capital that went in burdened with the obligation in the real world to repay it.
Well, that was what we're discussing. There was...
But I understand it's a real world obligation, but the Court of Appeal held against us on the credits point by saying that if one stood back and looked at the reality of it, it was always intended that this money was to go round in a circle. And this was the capitalisation by EHL of EIC was always, as it were, on the radar of Mr. Flowers and the various actors. But as I've endeavoured to point out, that wasn't on their radar. What was on their radar, on their legitimate radar, was the use of the triangular model to make a legitimate sister company profit, which could be exploited by the holding company to increase the capital. That's not achieved by removing 24 million of capital for nothing, which should never have been removed, and then purporting to replace it with 24 million, which comes with the obligation to repay 30 in the real world. Because, and the Court of Appeal, Lord, I'm sorry I interrupt you, but the Court of Appeal in fact said if EIC did not do that, the whole group would be in jeopardy. So it was lashed to the wheel, that's my expression, not the Court of Appeal's expression, to carry on with what we know and the judge found to be the improper payments of 8%, in order to repay that money. That is not in fact increasing EIC's capital. And we have a separate point, which I don't want to get lost, that in order, what EHL was doing was saying to the GFSC, we will put money in and therefore we can write more premium. When EIC received the 24 million or the 32.3 million, if we're taking all the money, it then wrote more business. That business came with additional obligations to meet claims. And I started by saying, although it was in very simple terms, important to the submission I then want to make subsequently, that in fact, if one looks at the simple analysis of the cases, and I'm talking now about Charles Villeneuve and Tayuta being the two Supreme Court cases which actually, we say, resolve this problem in our favour. Actually, what came back to EIC should not even be constituted as a benefit, because it came back with strings attached. It had 24 unencumbered million, and it then got back 24 encumbered million in reality.
You're going to take us. You're going to have to take us to the cases.
Yep.
Can I just pursue the point that my lady raised a moment ago? If we analysed a lot of case law in Gatwick Investment,
yes,
going back hundreds of years, and the cases were analysed as suggesting that the test of whether you take the third party's payment into account essentially depends on whether the purpose of making the payment was to benefit the insurer or the wrongdoer, as the case might be. And if one applies that approach, then that, on the face of things, works in your favour here.
Indeed.
Now, on the other hand, one could have, in a situation like the present one, a parent company which, in perfect good faith, is concerned about the undercapitalization of the insurance subsidiary, borrows on the German bond market in order to capitalize the insurance company. And I think a concern may be that if one looks at the Swinson judgment, then that might suggest that if, as a matter of fact, the the trust fund has been restored, as it were, then that works automatically by operation of law to discharge the obligation of a wrongdoer, regardless of whether that was intended or not.
Well, two things about that. I will take you now, if I may, to Tayuta and the very short references. But can I just introduce where I want to go with this? Is that I think it's right to say that the Tayuta analysis says that there are three tests. One is a payment of benefit. Well, you've got our submissions on that, but whether you agree with them or not is another question. But you see what we say about it not being a benefit. That's our ground three. And I've briefly gone over that argument.
So that's your point. It didn't help at EIC. It just kept them lashed to the wheel or whatever.
Yeah, it wasn't then a benefit. And that's my 54 million over 24 million point. That's not a benefit at all. If we then go to the second of Lord Sumption's tests, which was attributability, and I'm going to confess my ignorance as to whether I should say attributability or attribution. But you know the point I mean. In other words, that the credit, the payment for which credit is sought, has to be attributable to the events which caused the loss. That's his second requirement. And we would invite your lordships to apply that and say, in this case, the events which caused the loss are very clear. The event that caused the loss is solely Mr. Flowers' dishonest operation of a abused and distorted triangular model to extract 8% of gross written premium for nothing, which he could use as he saw fit. That's the event that caused the loss. What brought capital back into the company was an independent decision by EHL that it wished its subsidiary to keep going, in which event it had to appease the GFSC. The only way it could do that was to put in either money that it held in the bank, the 8.3, or to borrow money which had come out of EIC and disappeared, the 24. That's what it chose to do. So
Well, you could characterise that as needing to replace some of the money that had been taken out.
Well, only if EHL was involved in replacing money that it knew had been taken out improperly.
Or did it not?
Well, there's no, because we've settled against EHL, we settled against Rowan, we settled against everyone else, even if they were directors of...
But EHL is Mr. Flowers and somebody else, isn't it?
Well, not just Mr. Flowers, but they had a board of directors, they had a board.
You know, causation's a very, as everybody knows, a very difficult concept.
It is.
I mean, here, a test of but-for causation would certainly be met, because but for the defalcations, the recapitalisation wouldn't have been necessary.
Yes.
But I suppose you might say that the proximate cause was the decision of the parent company to borrow, the willingness of German lenders to buy the bonds, and then the investment of the money in the insurance company.
Lord, may I say with respect, I entirely agree, and we did notice that when we read Mr. Poole's submissions, he was referring to proximate causation. We had referred to whether the credit, so-called credit, was attributed to the events which caused the loss, and we were working on attributability. We did give consideration to whether, in the facts of this case, there's any material difference between those two concepts, and concluded that we couldn't see one of any relevance to this court, because if it's limited to the facts of this case, there is no difference. We then read the Gatwick case, which was brought to our attention very, very helpfully. Thank you very much for that on Friday. And we concluded that other than for the intention question, which I needn't go to the submission, but we have a submission that if that's the test that your lordships think might be applied for the question of collaterality, come back to collaterality in a moment, if that's right, then it would operate in our favour. But before we get to collaterality, which is Lord Sumption's third threshold, we're still on attribution or attributability. And the question there is whether we call it attributability or whether we call it but versus proximate causation. On the facts of this case, we think makes no difference at all. But it may also inform intention. If your lordships, for example, were to think that the intention of EHL was to borrow, to inject money to keep EIC going at the behest of the GFSC, then that only becomes the restoration of the trust fund, Lord, by analogy, if you hold against us that the sum is to be credited, because EHL wasn't consciously restoring any trust fund. There's no judicial finding that it was. I'm calling it a trust fund just to
Yes.
keep the analogy going. I'm not suggesting it's a trust fund in legal terms. And therefore, whether one looks at intention, attributability in Lord Sumption's second test and iota, or whether one looks at proximate versus but-for causation, you come to exactly the same place. That looking at what EHL did, what it did was not attributable to the events that caused the loss. What caused it to do it was the GFSC seeking greater capital.
There is a question, though, as to whether causation is a requirement at all. I mean, one of the insurance cases that we discussed, you might argue there's a difference, but maybe there isn't, between insurers and wrongdoers, but one of the insurance cases was one where fire damages the property. Insurers pay the insured the fire damage, and then the insured receives, because the insured has already agreed to sell the property to somebody else, and this fire happens before completion, but it doesn't affect the obligation to pay the purchase price. And it's held that purchase price extinguishes the loss, and therefore the insurer can get the money back. Now, there's no causal connection between the fire and the obligation to pay the purchase price. They're totally causally unrelated. And yet, the payment by the purchaser reduces or extinguishes the loss. So you can, if a payment is made without the intention, a payment can just extinguish a loss if it's made, even if it's not causally related to the event where the loss is incurred in the first place.
I absolutely understand that. And of course, if one has an insurance policy, which this is the difference, we're an insurance company, but we're on the different end of this argument.
Yes. If
an insurance policy exists, it's only triggered if there's an event which causes the loss. So to that extent, whether you get an insurance payment made to you is directly attributable to the events that cause the loss. And to that extent, it's completely different. But that's why the law, we would respectfully submit, has created the exception of credits which should be considered collateral. Because insurance is not credited, if you'll forgive the double negative. The law doesn't fail to credit an insurance payment because it's not attributable.
No.
It doesn't credit the insurance payment precisely because it should be considered collateral.
Yes.
The lordships have got our argument that we say this is collateral if it's not attributable.
Yeah.
Having said that, obviously one imagines that this court's going to be more interested, I would thought, at the moment in the attributability argument than on the collateral argument, because to a large extent the factual matrix which would lead you to say it's not attributable feeds into the collateral argument as well. But in addition, just so I don't forget it, because I'm going to have to press on in a moment, but just so that I don't forget it, we do say that the money that came into EIC was for the most part for the subscription of shares. That's the 32.3. Now, we maintain, with respect to the Court of Appeal, that they were wrong to dismiss the fact that there was, in effect, a contract under which that money was paid, for which EIC gave benefit. They put us down on that on the basis that, well, it wasn't a real benefit. But let me just rehearse the arguments in very brief terms, which you would have read, but just so that I've made it orally. The money that came back in was undoubtedly, other than for the rebates, which we're not talking about at this stage, the money that came back in subscription for new shares for which shares were issued. Now, that is a contract of value. We would respectfully say the Court of Appeal went down the wrong track, if I may say so, by then trying itself to work out whether that was of real value or of notional value. Because when it comes to consideration, actually, the court doesn't involve itself in that. And the law on that is strong, and it's been around for a long time, and it's not subject of any rational argument. So whether the consideration which was given for the shares, for the money, was a piece of paper or a piece of paper with commercial value attached to it is neither here nor there. What it did do was to increase its shareholding and issue shares accordingly. The fact that EHL started by being 100% and ended up by being 100% is neither here nor there.
But there you are asking us to take a rather legalistic view, whereas when you were talking about EIC's, well, it was really in the real world under an obligation to pay the instalments on the loan, even though it had no legal obligation to do so. There you're encouraging us to look at it in the sort of the economic round, whereas here you're saying don't look at the economic round, just look at the subscription of for the shares.
Well, Lady, I would respectfully submit that we're entitled to do that because the second of these is a legal question. The first of these is a way of grappling with the attributability question, which is factual causation, and I don't quibble with the idea that it's difficult. I don't, if I may say so, I don't quibble with the idea that Mr. Flowers would never understand if he lost this point, because it's a difficult point. Now, I don't say it's a difficult point because he ought to be winning it and we ought to be losing it, but I understand that anything to do with causation can present problems.
But this point you've just made is the first point, really, isn't it? Because if it's correct, it's an answer to the whole argument. And nothing was ever replaced. All that happened was new shares were issued and paid for.
That's one of the arguments.
And that's end of story.
That is the end of the story. That's the essential argument which we ran at trial and prevailed. That was a adventitious, the result of an adventitious gain from an independent third party pursuant to a contract, which would be a way of just summarising that principle. Absolutely correct.
And that applies to the 8.3 million as well as the 24 million.
Indeed it does.
All the money was put in through issues of shares, and so all that happened was that money was paid in return for various obligations under those contracts.
Absolutely correct. So then Lord...
And that's the legal position. It's not suggested they're shams, the contracts. You can't look through that legal position.
Nope. Quite the reverse. It was never suggested.
And if that's the way they choose to structure the business, well, then those are the consequences.
Indeed so.
Nothing was ever repaid that was taken out.
Yeah, money was repaid. Money was taken out, but that money was never repaid.
Or nothing to compensate for it. There were just separate transactions in which shares were issued.
Correct. So that applies, in relation quite right, to the whole of it. Now, the reason I started with the 24...
Can I just ask one question?
Of course.
You say that you also sued EHL and they settled, or the liquidators sued EHL, is that what you said? When they, in that case, did EHL claim or assert that the payments approved by their directors for the subscription of these shares was a payment made in breach by those directors of their fiduciary duties to EHL, and therefore the money was liable to be repaid in some way by EIC to EHL?
Lady, my recollection is no, and that's what everyone else behind me thinks, but none of us have addressed that point in preparation for today by going back to the pleadings, but my recollection is very clear that EHL did not assert that the decision taken on its behalf by its board was improper. And therefore, that would support the starting point of this court, there being no finding against EHL, and there no finding against EHL's directors. And the only finding against Mr. Flowers is in relation to his conduct as a director of EIC and in taking money from EIG for services he had not provided under a false invoice. I'm right in recalling that no such allegation was made, milady, but in fact they didn't put in a defence. So there was a stay, I think, on that, and it was subsequently set. So I was just about to explain, however, that I didn't want the 8.3 to get lost in the wash of the 24, because we do have an overarching argument in relation to the full 32.3, as Lord Leggett has identified. But the reason I started with the 24 is because it does have an additional factor or two relating to it, which makes clear that it was not attributable to the events that caused the loss. And the point here is, and I'm not going to go into the detail, but when you look back at, remind yourself of what Mr. Poole said, what he tries to do is to say, well, it's all really one big transaction and therefore it should be credited. We respectfully say the events that caused the loss are very clear and very narrow. The events that caused the loss are the improper extractions of the 8% for no service. That's it. That's the event that causes the loss. And therefore, when you come to look at the money which had to be borrowed, there's an additional factor.
But once you're down into the track of looking, this seems to me to show the problem, really, once you start to dispense with the legal structure and just start looking at economic effects, it's unclear where you stop. You know? You're then carrying it to the next level and saying, well, really, it was the insurance company that was servicing the debt. Well, we're ignoring all who the entities are there, aren't we?
Well, my Lord, what I would like to say in answer to that, and I hope it doesn't sound in the least bit opportunistic, is that I understand entirely the difference between, as it were, a legal or in-the-round factual approach. But if one is going to stick with the legal approach, then it is absolutely clear that the borrowing of £24 million and the paying of a further £8.3 million was not attributable to the events which caused the loss. They were attributable to a desire to put money into EIC. And that is the position. And we start with the proposition that EHL was always independent and had no obligation to use any money that was dividended up to it.
But if the 24 million had stayed with EIC, would it then have been adequately capitalised to do the business that it
Well, lady, we're into a hypothetical there, because as I've said to you, there was always a desire and intention and plan of Mr. Flowers and his finance director to write premium ahead of capital. Whether they would have done that in circumstances where the 8% hadn't been extracted, we don't know. And there's no findings on that, understandably, because it would have been rather hypothetical form of cross-examination, I think. The trial judge would have still steered clear of that, I think, even if we'd asked him to consider it. Whether new capital would have been needed, we don't know. It might well have been. New capital might well have been needed if, in fact, whatever came out of EIC, there was always a plan to write business ahead of capital, to run an undercapitalised business in reality. So I'm not sure I can answer that question, but I don't think it can be assumed against us that one way or the other. I just don't think it's pure speculation. It's a speculation about which we on our side might have a view, but I don't think it's right for me to speculate, because that's extending beyond the four corners of both of the relevant judgments that your Lordship's going to be looking at for the purposes of deciding the appeal. So I'm trying to be quite careful, remaining within those four corners.
But does your argument depend on us deciding that actually it was not in EIC's best interest for it to be kept going?
Well, because the money that came back in, that it's. If you forgive me, do we know or not? Well, that's not what we're saying. No, we're not. I don't think we can go there. But you could say that it wasn't in EIC's best interest to be capitalised or ostensibly capitalised by a large amount of money which it had to repay, which itself would burden the company with additional underwriting and thus burden the company with additional claims. So if your ladyship wants to consider that possibility as part and parcel of the overall effect of the debate...
No, I'm asking whether you want us to consider it.
No. We do not need you to find that it was in EIC's best interest, is the simple answer. But if you're not inviting me for views on what may be in your mind, I won't go further. But I've made the point that EIC gets money back, which is burdened with new underwriting, new claims, and the requirement to repay, where it lost money originally without that burden.
Yes. An aspect of this that's occurring to me is that there's a point in time when, on any view, given the findings and fact, EIC has a claim against Mr. Flowers for damages in respect of the money that had been abstracted wrongfully.
Yes.
And the issue is whether the payment in by the parent company is to be treated as having discharged Mr. Flowers' obligation. Now, one can imagine a scenario where, say, for example, I'm a partner in a business and I discover that one of my fellow partners has been guilty of embezzlement. And he's my brother, and I decide to return the money in order to avoid any action being taken against him. Then one might in that situation say the firm can't take the benefit of the money that I've put in order to save my brother from disgrace and at the same time pursue him. Because this is going back to test of purpose.
Yeah.
On the other hand, where you're talking about a parent company, could it even, intra vires, decide to do that effectively, to pay money in order to discharge a wrongdoer's liability? I mean, let alone whether it did in fact, could it properly do that?
Well, I don't think it could.
No, and there's been no suggestion in this case, as you tell us, at least there's been no finding in this case, of improper behaviour on the part of the directors of the parent.
No.
Well, that was the question I...
Yeah.
The answer there's no finding, for sure. But, Lord, I would respectfully submit that the directors of EHL could not conceivably have used EHL's money in order to discharge Mr. Flowers' obligations to EIC. And going back to your Lordship's first example, one might have an interesting debate at that point about two things, because the focus of Gatwick was in respect of whether the payment was a voluntary payment, which we know was resolved against voluntariness because it was a statutory obligation. And the second was that the question of intention. Now, if one were to import those here, there would be, I think, a clash of the debate between it being a voluntary payment on the one hand, which might suggest it was collateral, even if it was the brother, to relieve the brother's position, which would suggest you wouldn't credit it. But if you were concentrating at that point on the intention route, then you'd be inclined as a court to want to perhaps respect that. But how that would be resolved, I'm not going to try and speculate on my feet, but I can see that being the centre of attention at that point.
But suppose that, yes, it's my brother. I don't particularly like my brother, so I'm not in the business of trying to stop him. But I want the company to succeed, And so I put the money in so that the company has not lost money. So what I've done by putting my money in is to, which is what happened in Swinson, is to remove the loss suffered for which the company might otherwise have sued the person liable for the loss. And that's in effect, the loss has been avoided by my payment in. And so even though my brother was still a wrongdoer, there's no compensation due because I haven't suffered any loss.
Well,
I mean, it's a very nice distinction to try and see whether the intention is to put the company back in funds for the benefit of the company and thereby actually removing the loss, or is the intention to do that in order to save my brother the disgrace of...
Well, one would still have the debate about whether it was whether one should credit a voluntary payment on the basis a voluntary payment would be considered collateral. I don't need to get into that because it may be fact-specific, but that argument would still remain. But your ladyship's example does not deal with, if I may say so, with the facts of this case, in circumstances where we know that there was a subscription contract for the return, if we like, or the payment of £32 million for shares. That's not quite the same as someone making a voluntary payment by putting £100 back in the safe or the till which has been removed. There are also in the examples that all three of your lordship have put to me, there is an absolute direct link between the desire of the payor to resolve the illegally extracted money. So that desire arises directly from, one might say, from the events that have caused the loss, because one's looking at one's brother, my brother's stolen money, I'm going to put that money back in the company to prevent him being sued or prosecuted. That's a very different question, because here in this particular case, we're not dealing with those facts. We're dealing with facts that there is nothing to suggest on the facts that EHL took a decision to subscribe for shares in EIC in order to capitalise the company at the behest of the GFSC in order to resolve the problem caused by Mr. Flowers. Were one to speculate for the moment, just speculate for the moment, that EHL hadn't the faintest idea that money had been spirited out of EIC improperly for services which had not been provided, there's no finding that they did know, so on that basis one should assume that they did not, then it's impossible to say, with great respect, I would submit, that in fact what they were doing was intending to replace the money improperly taken, because they didn't know it was improperly taken. And that's why the analogy with the brother and the health of the company or the health of the employer breaks down on the facts of this case.
Well, yes, on the facts of this case, because we're dealing with this case and applying these principles on the basis of a long trial that's found all these facts. But the principle that we have to come up with is going to be applied in other cases before there's a long trial. And I'm trying to think, well, if the test is going to turn on what the company, the parent company, thought or intended or wanted to do by paying in this money, how is that ever going to be pleaded or ascertained at a trial if it's the subjective intention, which can be expressed a number of ways, of who exactly? Mr. Flowers, who was actually the director of EHL, or one of the directors, maybe it was his subjective intention to prevent EIC from coming after him for the money.
Well, it would probably have to be its expressly manifested intention anyway, wouldn't it?
Yes. But
Well,
Lady,
it then becomes as I say, you can rely on the findings of fact, but we have to come up with a principle that's going in future cases to predate all the findings of fact and determine what kind of facts a trial judge is going to have to look for.
Lady, I understand entirely your concern. But what I would say is we didn't come here in order to say that our argument turns on intention. I've only introduced intention this morning because that's arisen in the Gatwick case. It's arisen in the Gatwick case in circumstances where the court has said that actually, although there is a overlap because of the wording, I think it was in consequence of, the in consequence of wording of the policy, there is some overlap with common law, but expressly you said, as I understood it, in the Gatwick case that you were making findings in relation to the insurance world and insurance credits, not in relation to common law credits.
But the principle of going to purpose was established long before Gatwick and in quite other contexts. Hodgson and Trapp, House of Lords on whether you give credit for social security benefits in calculating damages for personal injuries, or Parry and Cleaver, and before that, another House of Lords case, and whether you give credit, for example, for charitable schemes to relieve the victims of some disaster, whether that should be taken into account in deduction of the damages recoverable from the wrongdoer. It's all to do with, it's always, in case after case, its purpose is the test that's applied.
Yeah, one understands the purpose, but all I wanted to suggest is that here the purpose can be divined from, without going into subjective intention of the individuals. The purpose is to comply with the requirements of the GFSC to put capital into the company, which is undertaken by an independent holding company with no findings of wrongdoing against them in circumstances where they couldn't possibly have been making a decision to replace Mr. Flowers' liability, not only because there's no evidence that they knew about it, but also because it would be ultra-vires. And therefore, on the facts of this case, perhaps I ought to finish with this request to submission to your lordships, is that, if I may say so, I'm not sure it would be right that your lordships have to fashion a principle today out of this case, which is going to be redefinitional of the law of credits. The law is established in the Toyota case, and let me perhaps just remind you of what I'm saying about that. The law is established by reference to the three tests of I've said of Lord Sumption, but enunciated by him on behalf of the court in Toyota, which was that first of all, the payment which is sought to be a credit has to be a benefit. If it isn't, you don't get to base 1. If it is a benefit, it then has to be a benefit which is attributable to the events which cause the loss, which is base 2. And if you get to that stage, and that stage only, you would then go on to consider whether it's an attributable benefit which should be disregarded for reasons of it being collateral. And that the insurance policy payout is a classic example of invoking that third test in circumstances where the second test of attributability is obviously met, because the insurer wouldn't have to pay out unless there was a loss. It was directly attributable to the event that causes the loss. But that's not the position here. So my respectful submission to this court would be, all this court needs to do is to apply that principle to the specific, case-specific facts of this appeal.
The way Lord Sumption puts it on page 2048, paragraph 12, in the middle of the paragraph, just after the citation from Swinson, he says, leaving aside purely benevolent benefits, the paradigm cases are benefits under distinct agreements to which the claimant has given consideration independent of the relevant legal relationship with the defendant. So you would say, I suppose, that would apply to the agreements under which the shares were subscribed for in the present case.
Lord, yes. So it's noticeable that we've put our appeal, in fact, we run our submissions below on a very limited number of authorities, and our submission in the Court of Appeal on a limited number of authorities, because we wanted to start with the Supreme Court Privy Council decisions and just apply them. And if we start with the three-part test of benefit, attributability, and if you don't get past both of those, then that's the end of it. And if a defendant manages to get past both of those, then you only then move on to collaterality. Then in those circumstances, on the facts of this case, we say it fails on the grounds of benefit, attributability and collaterality, but I can quite see a lively debate about whether on the facts of this case, the last two really distinguish each other one from the other, because the factual matrix which would cause you to look at whether it's collateral are not dissimilar to the ones that look at attributability. The one which might cause you to look at collaterality separately, engaging the adventitious gain from an independent third party, is the share and contract and subscription point. Because that isn't, well, but you could also say that's part of the facts that says it's not attributable. Because the payment of the 32.3 million is in fact attributable to the grant of new shares. That's the if whether you were talking about attributability or proximate causation, that is where the argument would be. So I'm reluctant to get involved too deeply in whether we're looking at attributability or collaterality here, because the facts are the same. But I can see there is a functional difference between the adventitious gain point, the subscription contract point, and the simple point of what they were doing and why when they put the money into the company.
So why do you say that the 8.3 wasn't a benefit to?
Well, it came for the same reason as the 24. It came back as new money, and with an obligation for it, which would then cause the company to write new business, and that would come with its own set of new obligations. But I think I've made not a concession, but the obvious point that some of these arguments are stronger when the money is borrowed than when the money isn't borrowed. That's not a throwaway line to say I'm abandoning the 8.3. Far from it. But there are additional arguments which attach to the money that's borrowed. Lord, I'm not quite sure. I'm going to have to, I think, decide how best at this stage to proceed, because I'm very close to being out of time, and I've only dealt with half of what I'm supposed to deal with. But be that as it may, I wonder if your lordships would allow me at this point then just to introduce Icebreaker and say in 5 minutes or 6 minutes, to stick with time, what we say about it. The first point about Icebreaker is this. Mr. Flowers' appeal is limited in scope, and his case statement of last month exceeds that scope. And I can make good that, but there is a large amount of material in his statement of case which have no place in this appeal of any kind whatsoever. Let me just give you the headlines.
Are there grounds of how are the parameters of the appeal defined? You say, are there grounds of appeal that set it out? Of course, there are the issues that were argued in the Court of Appeal. Yes,
we've got the grounds of appeal, and then we've got the further explanation of those grounds of appeal.
Right.
And let me just give you all I can do at this stage, if I may.
Give us the references.
Yeah, is just give you. The references. The further explanation is at tab 12, page 665. That is a document which is drafted by leading and junior counsel who appeared below.
Page?
Sorry, Lord, page 665 of the bundle, tab 12. And that is exclusively devoted to clause 11.4 and public policy. Exclusively. So where we get to, and if I just give you the headlines, as best as I can do, I'm afraid, is paragraphs 3 to 7 of Mr. Flowers' statement of case all relate to facts dealt with the trial judge and attacks on the liquidator, which are just not open to him to make in this court. Paragraph 11, there's a factual assertion that in some way Mr. Flowers had provided reserves for Icebreaker by saying they were within the premium charged and so on and so forth, but there's just no factual basis for him to do that. There were no reserves for Icebreaker, and that is held by the court to be the case. Finding of fact that he has not appealed. Paragraphs 12, 13, and 16 all assert that he relied on legal advice. You get those at pages 92 to 93. But it was found by the trial judge that he had not relied on legal advice. That was upheld by the Court of Appeal, and no material has been placed before your lordships to invite you to embark on a factual analysis as to whether those two courts were correct. Paragraphs 31 to 41, which we can, and paragraphs 59 to 65, significant number, 31 to 41 and 59 to 65, constitute an attack on the liquidator and his motives. That was run at the trial. It was soundly rejected by Mr. Justice Restano, who said in his judgment that the attacks on Mr. White's motives should be, and I quote, consigned to oblivion, close quotes. Those attacks are not before this court. Paragraphs 42 to 44 are facts dealt with by the trial judge and not appealed. And 45 to 50 attempts to run an appeal based on relief, which was rejected, statutory relief, that is, which was rejected. There's no material before your lordships for you to even consider it. So the first point is, when you come to look at Mr. Flowers' appeal, and he may wish to deal with this when he moves his appeal, is to consider its scope. We would say its scope is very limited. Its scope is limited to saying that there was no tort because there was no loss. And there was no loss because of clause 11.4 provided an exclusion, and otherwise there should have been a defence of public policy. Now, the Court of Appeal and the trial judge both said that that didn't eliminate loss in any event because he was found guilty of a wide range of negligence in relation to Icebreaker, each of which could have produced other losses. So first of all, it doesn't eliminate loss, but nonetheless, whether clause 11.4 should be construed as he wishes it to be construed is an issue which needs to be resolved, as does public policy, but it won't eliminate the loss, and of course it wouldn't be relevant to anything other than a tort case. So I now move on very briefly, and I hope you'll forgive me doing it in this way. Clause 11.4. Can I just spend 2 minutes on Icebreaker? It's a tax avoidance scheme. No one's ever said otherwise. It's not a tax evasion scheme, and it was not asserted at trial that it was tax evasion. Secondly, it used as a model something that your lordships may well have seen before, which is to attract sideways loss relief for professionals or business people in the following circumstances. If you earned £1 million, you'd pay, let's say, for the sake of argument, $500,000 in tax if you just take a 50% marginal rate. If you persuade HMRC that you had in fact invested £1 million in a collateral business, and that £1 million was lost, you would eliminate that obligation to pay tax. That's it. So, but no one wants to invest £1 million and lose it in order to save 500,000. So the schemes that came up, and they all had a very similar formula. And if I take 2 and 8, so I'll take 1 million, 200,000, 800,000, you'd put in 200,000 of cash, and the scheme promoters would arrange for you to take an £800,000 loan from a bank. Half the cash would go off to the scheme promoters in fees. The 100,000 that's left would be invested at risk, and various ways were found in order to ensure that the other 800,000 actually never got lost. But nonetheless, the schemes were structured in a way that the full £1 million was put to HMRC as going into the first year loss of the LLP. Now, the tax scheme failed. There was more than one scheme, but the basic Icebreaker scheme failed, so it did not achieve its tax objective. So the tax was due. Now, the £200,000, which was the cash that was put in by the individuals on that 2/8 analogy, was insured by EIC. And EIC came off risk if profits of 200,000 were made. In other words, sufficient came back from the 100,000 invested to repay the 200. Or if HMRC or the tax tribunals permitted the first year loss of the £1 million. In either of those circumstances, EIC came off risk. There was also a 5-year long stop, but we needn't worry about that in this case. Now, as I say, the tax scheme failed, and therefore there were claims made on the policies. EIC rejected those claims pre-liquidation, and the 2 grounds of rejection which remain relevant are 11.4 and public policy. When we look at 11.4, all it says is there's an exclusion clause which says that the insurance company is relieved of obligation to pay, liability is excluded if the LLP and the investor, the policyholder, collude to bring about the failure of the LLP.
So that's collude to result in a loss of the 100,000?
Or 200, because the 200 would be the insured amount. It's the 200 that's insured.
Yeah, but only 100 was invested.
Only 100 invested, but the 2 was insured. So one of those, roughly one of those went in fees, and the other was invested. But the 200 was the insured amount relating. So you'll see when you look at the exclusion clause precisely what it says. But it excludes for colluding, for there being a collusion between the LLP and the policyholder.
There's a reasonable suspicion of collusion, I think.
Sorry?
It was a reasonable suspicion of collusion, I think.
It had to be based. It could be based
reasonable belief
on the company's
Yeah.
on the company's belief. Yes.
Belief.
Yes. Now, the point was raised by us. The one had to decide when that exclusion clause, when this collusion could have happened, because the members of the LLP come into the LLP. The scheme of the LLP is fixed from the start. There's nothing they can do to change it. I'm going to come back to that in a moment. They come into the LLP, but of course then there will be options to make investments pursuant to professional advice, but the members would be able to vote on that. So if there was evidence that they'd been offered one very good investment and one absolute stinker of an investment, it could be said, factually, I'm just speculating, that there was therefore collusion at that stage between the LLP and the members to bring about the worst result they could. But no such allegation has ever been made. There's no factual basis for it. It was never asserted by Mr. Flowers at any stage of this case. He now accepts in this court, by how he's put his case, that 11.4 has to operate as an exclusion at the very moment the policy is incepted. Because you can't sign the policy until you're an LLP member. You ask to do both if you want a policy at the same time. So there's a scintilla of time maybe where you're still where you're an LLP member but not a policyholder. But the factual matrix against which this construction argument has to be run is that it was crystal clear on the findings of the trial judge that Mr. Flowers knew at all material times that the 800,000 loan would be in a blocked account and would not be invested. It's also a finding of fact which he cannot appeal and doesn't appeal, that he would have known that astronomical returns would have been required in order to have, over 5 years, got to the replacement of the insured amount if all that was being invested was a percentage of the insured amount. So if 100 went in fees, 100 was invested over 5 years, you'd have to turn 100 into 200. There's clear findings from the court below and the Court of Appeal that he knew that. He also knew that any investor who asked for his policy was not able to change the structure of the Icebreaker scheme. They had no ability to alter it. So he knew precisely what they were signing up to. And therefore, it stands absolutely crystal clear that his case must be that if you took a policy for a scheme over which you had no control, which then failed its tax objective, 11.4 automatically bid. So there was never any cover. And he doesn't shrink from that. And in fact, his evidence was, I didn't need reserves because there was no cover. Well, whether that was accurate evidence or not doesn't matter, but that's his case. So then you move to the question of how to interpret clause 11.4. And we've given you the law in our statement of case that there is clear authority that you would interpret an exclusion clause in an insurance policy in a way which allowed there to be an insurance policy. So in other words, if the exclusion would always eliminate liability, then you would not construe it in that way. And indeed, Lord, if I may say so, when I first read Gatwick, what had come through to me on my screen was just the case reference and not your Lordship's reference to the issue to which you were bringing it to our attention for. So when I first read the first half of Gatwick, immediately I saw that it all actually went to how to construe an insurance policy, and that you would in fact construe it in favour of there being some indemnity arising from it rather than construing it the other way round. So that whole section of Gatwick, if I may say so, wholly supports everything we have said about clause 11.4. I needn't take you to the paragraphs, you'll be well familiar with them. But in fact, it's crystal clear, we would respectfully say, that Mr. Flowers does not shrink from and cannot shrink from the proposition that either he came off risk because HMRC allowed the loss to be written down, or if it wasn't written down, he immediately came off risk because the structure of the scheme was struck down, therefore there was collusion. That we would respectfully say cannot conceivably be the correct answer. The correct answer would be there is no evidence of collusion, and were he to have thought that sorry, I've lost the thread I was about to say to you, do forgive me. Were it to be considered that the very moment of entering into the LLP membership of the policy invoked clause 11.4 if the scheme wasn't permitted, then the policy would have been written in a very different way. And I, on the face of it, can't actually really imagine anyone signing up to it, because there wasn't a question, therefore, of you could win either way. You couldn't. You were always going to lose, because the collusion that he relies on is built into the scheme. And the additional problem he has, for the purposes of factual matrix construction, is that he knew that the basis upon which the scheme failed was built into the scheme and that the members couldn't change it. So that's all I want to say about 11.4, and may I commend what we've said earlier about it. I then want to move on very quickly then to public policy. His second argument, which was run below, and is that the court should strike down an insurance as being unenforceable if it insures a loss pursuant to a tax avoidance scheme. That's his case. Now, I need do no more than this in one view, which is to commend to this court the analysis of that argument by the Court of Appeal and say that there is nothing about it with which we disagree or would wish to add. But there is one point that I just wish to elucidate. There is a reference in the Court of Appeal's judgment and perfectly properly so, because it was raised by Mr. Flowers, there's a reference in the judgment to decisions of the administrative court and a court of appeal sitting on appeal to the administrative court relating to attempts by a group of policyholders to seek compensation from the Financial Services Compensation Scheme in England. So that was sought on the basis the compensation scheme is there to step in when an insurer goes illiquid. This insurer was in liquidation, and therefore they asked the FSCS to meet the £200,000 or whatever it was in their individual case. That got turned down, and you'll see references in the judgment to what the administrative court said about it. Our answer to that was, with the greatest respect to the administrative court, it was a public law decision. It was done in short order. It did not address questions of private law, which this does address. But you'll also see reference to Patel and Mirza. So, and regrettably, and I have to, there's not a detailed reference to it in the Court of Appeal, but they say it also looks as if the FSCS didn't quite understand the law and had caused the court to misstep in looking at the public law decision.
Which case was this?
I'm sorry. Patel and Mirza is the authority that I'm now going to refer to. So, and that figures, that actually is part of Mr. Flowers' appeal on Icebreaker, so I have to deal with it. And the argument goes that Patel and Mirza has introduced a range of factors test to whether public policy bites to decide that a contract is void. That's the argument. Now, that was the argument run by the FSCS before the administrative court. And with the greatest respect to them, they misunderstood it. And I'm just going to, and that if I may say so, speaking for myself, if the First Instance Court and Lord Justice Coulson had been made aware of actually what the structure of the law was, they would have expressed themselves very, very differently. Let me just explain in short order what it is. Chitty makes clear that there are two broad categories of case falling within the general heading of illegality and public policy. That's actually what Chitty uses as the chapter heading. One is illegality in the narrow sense, meaning that a contract involves the commission of a legal wrong. And you may remember the famous footnote where they talk about an agreement to sell a knife to someone for the purposes of committing a murder. And the second category is the broader category of cases of public policy which do not fall into category one. Now, the first, a narrow category, was once summarised as extirpe causa, illegality, then became known as the rule in Tinsley and Milligan, was then replaced by Patel and Mirza to introduce a range of factor test for public for illegality. The mistake made by the FSCS in making their submissions to the Administrative Court was to elide categories 1 and 2 and lead the court to think that the more flexible range of factors test in Patel had somehow made the court's approach to Category 2, in other words, when it would apply public policy rather than illegality, more flexible. And it undoubtedly did not do that. Patel and Mercer was all about illegality, not about public policy. Now, it was never suggested by the FSCS that the policyholders had been involved in any conduct which engaged the Category 1 type of illegality, and it's never been suggested in this case. No one has suggested they did anything illegal. What they did was enter a scheme which had a tax objective, and that tax objective was failed. That's all. So the reliance on Patel and Mercer is completely misplaced as a matter of law, and there is no range of factors, flexibility introduced into whether this court would wish to embark on what I think in one case were called the choppy waters of extending range of public policy. If I write about that, then your lordships will be faced with there being not a closed category, but an existing and fairly established category of public policy, none of which would cover this case at all. And this is all covered in the Court of Appeal judgment in circumstances where the Court of Appeal has listed out two strands of law. One is 100 years of Supreme Court, House of Lords authority saying that it is entirely possible and legal for people so to order their affairs as not to pay tax and engage in lawful tax avoidance as opposed to unlawful tax evasion. That's strand one, and you've got the references in our statement of case. Strand two is that Parliament has consulted on how to deal with what became known as aggressive or artificial tax avoidance schemes and introduced the General Anti-Avoidance Rules, the GAAR, giving HMRC and the courts greater powers to deal with them. And therefore, we would respectfully submit that the Court of Appeal was 100% correct, as was Mr. Justice Fasano, in declining the opportunity to create a new category of public policy in which this court would decide, because it doesn't like tax avoidance, if that was to be the position, that it could then strike down any contract which was connected with the tax avoidance scheme, because presumably if it's an insurance policy, it would have to be any contact connected with it. So I ought to make clear that taking in this insurance policy was not mandatory. It wasn't a mandatory part of the scheme, it was entirely optional. So in short order, that's what I would wish to bring to your attention on those 2 points. I've got other things I would very much like to say, but to be fair to Mr. Flowers, I have to give way to him and hope that I have enough time at the end to pick up any points which he raises, which may interest your lordship in things that I haven't talked about.
Thank you very much,
Thank
Mr.
you very much.
Jones. Now, Mr. Flowers, you have an opportunity now to address us.
Thank you, my lord and lady. Before I start on the no loss or the credits point, I think it's very important that I just correct a few points that Mr. Jones made earlier. Mr. Jones talked about a £24 million shortfall that we had to fill from capitalisation, and I hope Mr. Jones has only inadvertently misled you on that number. Mr. Jones missed the point that actually they gave credit at the end of the original appeal for £12.4 million worth of rebates. That was money that had gone to the service company and that we actually credited back to the insurance company. And effectively, that changes the numbers quite considerably. You will recall, I think, from the papers that the liquidator's claim on a joint and several basis against the directors was £48.7 million. The credits point that we are here debating at the moment is £32.3 million, which includes £8.3 million of money that went to the service company, went to the holding company and was effectively issued back to the insurance company by way of share capital. I would say, and I do believe, and I can't find the reference at the moment, that there was a distinction made as to why we undertook rebates and capitalisation, which was a point that was actually covered with the auditors at the time. But the reality, therefore, is that on Mr. Jones's omitted 12.4 million, the figure that was actually returned to the insurance company was effectively £44.7 million. So this notion of a £24 million difference is
So what was the figure of rebates from EIG directly back to EIC then?
My lady, the rebates were passed from EIG back to EIC by way of rebates. So they were just, it was a credit back effect.
But what was the figure for that?
£12.4 million. That is conceded actually by the liquidator at the end of the trial, the original trial in front of, sorry, forgive me, Justice Rustano. Another point really just to clarify at this point, Lady Rose asked whether EHL had sued any of its directors for breach of fiduciary duties. Mr. Jones said he didn't think so. I can categorically tell you that that is the case. I was one of those directors, as was my fellow shareholder, and there were common directors in EHL and also in EIC. So categorically, that is the position. And I would also say that there was no action taken by the bondholders to recover their money from EHL either. That actually was a question asked by the Court of Appeal at the time. The final point I would make, and this is really, again, just for clarity, is that it's very important to note, and again, this is in the original trial bundle, that £2.5 million was the initial capital, but actually of that 2.5 million, there was a loan originally from HSBC Bank. I think the original documents in the trial bundle suggest it was Royal Bank of Scotland International. We did change lenders, and the total amount borrowed, I think, from HSBC was £1.5 million. So, in effect, from day one, the 8% was required to go to EIC to pass up to EHL to service borrowings. I think the other point that is very important before I start is that it's important to note as well that during the course of operations over a period of time, not only was the 8% used for the things that Mr. Jones suggests, but it was also used to cover interest, and there was also capital repayments made via the holding company of in excess of £10 million as well, I think. I'm very conscious that we are 5 minutes before our due time to break. I'm very happy to start my proper submissions after the break, if that would suit your lordships, rather than do 5 minutes now and then cut off mid-flow.
Well, I think, Ms. Flowers, it might be a good idea if we were to adjourn now, and we can resume at 1:55.
Thank you, my lord.
And if you need the full time that you've requested, then you can have that, and we will adjust Mr. Jones's reply time.
Thank you. I think I'll be probably slightly quicker than Mr. Jones, but we'll see how we go. Thank you very much.
And the court will adjourn.